The first thing I look at when somebody calls about a medical malpractice claim is whether or not that individual suffered a significant injury or harm. Medical malpractice cases tend to be very difficult and they tend to be very expensive. So a lot of times somebody might walk away from a doctor's office and there was a procedure done or they had something occur to them that resulted in damages, but it's not significant enough to pursue. If there's going to be a case, there has to be some sort of catastrophic injury or resulting death to make it worth pursuing. The second thing that I look to find out on a medical negligence claim is whether or not the injury or harm came about from doctor error or if it's an accepted risk. Every medical procedure involves some degree of risk, and so we have to look at whether or not the harm came from the doctor's error or if the harm was just something that happened because of an accepted complication of that procedure. How do we do that? We hire experts or other medical providers in that field to review the medical records and documents and give us an opinion on whether or not there's a case. And I think that's why an individual will need to seek an attorney, because the attorney is going to know who are those qualified experts that will be willing to review cases and then give an opinion in that regard. Sometimes there may be negligence on behalf of a physician, but the resulting injury or harm isn't significant enough to make it financially feasible to pursue. And the reason why that may be is because medical malpractice claims are so expert-driven that we have to spend sometimes tens of thousands of dollars to obtain the necessary experts to provide the necessary opinions on the case. And if the damages aren't significant enough to make it feasible, even though there may be a case, it's just not worth pursuing. And so a lot of times we turn down cases based upon the degree of harm that was a result of the medical error.